Welcome to our program on CFIUS, the Committee on Foreign Investment in the United States, and today we are going to focus on China. Our guest speakers are Barry Taylor, Stephen Heifetz, Melissa Mannino, and moderator Thilo Hanneman. Thank you to our sponsor, Wilson Sonsini Goodrich and Rosati. They've been a longtime supporter of ours, and we've had the pleasure of hosting events in your Silicon Valley office with catered lunches, and we can't wait until we can do that again in person. This event came together very quickly. We have 213 people signed up today. In our high-level audience, we have our honorary chair, Jack Wadsworth, our chair, Ken Wilcox, quite a few board members, our groundbreaker and innovator members, and we also welcome executives from WSGR. I'm Margaret Conley, the Executive Director of the Northern California Center. Our format for today, I'm going to introduce Barry Taylor. He's going to give opening remarks and then introduce our moderator. Our speakers will have a moderated discussion, and then we're going to open it up to Q&A. If you have a question, please enter it in the Q&A box at the bottom of your screen. Thilo is going to be monitoring those throughout the program. All of our speaker bios are on our website. They're also in the chat box at the bottom of your screen. This event is on the record and we are recording. We have an hour for this program and we're going to end at 6 p.m. The public portion of the program will end at 6 p.m. Pacific. A few words about Barry Taylor. He's going to give opening remarks. Barry is our wonderful board member at Asia Society Northern California. He's a partner at the Palo Alto office of WSGR. He has 35 years of experience as a corporate and securities attorney and investment executive. Before WSGR, he was at the global private equity firm Warburg Pincus, where he was managing director in the tech media and telecom group. He worked on investments in the US, India, and China. His clients are from many sectors: software, clean tech, biotech, healthcare, the internet, and semiconductors. Barry, thank you so much for doing this. It's all yours.
Well, great, Margaret. Thank you, and welcome to everyone in the audience, and thank you for joining us for what I think will be a very interesting evening of presentation. As Margaret said, our firm is very active globally in technology. I work a lot on cross-border matters, so I'm talking a lot with the panelists, Stephen and Melissa in our office, about how do we approach an investment from overseas and in the CFIUS environment. So I'd also say the firm is a long-term supporter of Asia Society. We're very excited about the things that Asia Society brings in a very varied program format. We're sponsoring this evening's program, and we certainly hope that some of you in the audience will consider providing some additional sponsorship to Asia Society so that we can keep these programs coming during this period while we're all distancing. So thank you very much. Let me introduce now and turn this over to Thilo Hanneman, who is our moderator. Thilo is a partner at Rhodium Group. He leads the firm's work on global trade and investment. Rhodium publishes very, very informative, regular treatises and things on foreign investment. We work with them to give us a good sense of the market. Thilo supports investment management, strategic planning, policy analysis, and he's also a senior policy fellow at the Mercator Institute for China Studies, Europe's biggest China think tank, which is located in Berlin. So Thilo, thank you very much for agreeing to moderate this with my colleagues, Melissa and Stephen. Thank you for attending, and over to you. It's yours. Thanks.
Thank you, Margaret, and thank you, Barry, and very warm welcome to everyone out there in front of their screens. The United States has a very long tradition of exceptional openness to foreign trade, capital, and talent. And this degree of openness brings a lot of innovation and growth, but it also brings certain national security challenges. And the United States has several important regimes in place to safeguard vital national security interests amidst that general openness. Over the past decades, lawmakers have regularly updated these frameworks in light of geopolitical developments, changing security and risk assessments, and the evolution of technology. Since 2015, 16, we have found ourselves in such an updating cycle as the US and other countries have grappled with the reality of a rising China that has become an important player in the global economy, but has a vastly different economic and political system. Two of the most important areas of change in the past years have been, one, foreign investment reviews done in the United States here by the Committee on Foreign Investment in the United States, named CFIUS. And number two, export controls. Today, we want to take stock of these changes, explore the implications for Asian investors, specifically for California as an investment destination, and then also discuss how these dynamics may change under a new US administration. We're glad to have two excellent speakers today with us, both dialing in from their homes or offices in DC. We have first Stephen Heifetz, who is a partner in the Washington, DC office of Wilson Sonsini, where he advises clients on laws and policies at the intersection of international business and national security. Stephen does have a previous experience in government, and he served directly on the Committee on Foreign Investment in the United States. For those of you out there in the Bay Area, Stephen is also a very avid cyclist, so make sure that you grab him next time he's in town for a ride. Our second speaker tonight is Melissa Mannino, who's of Counsel in the Wilson Sonsini's DC office. She counsels and represents domestic and foreign companies on issues relating to foreign investment in the United States and compliance, as well as enforcement of the US export control and economic sanctions regulations. Stephen and Melissa, thank you both for joining us tonight, and let's jump right into the substance. I know for these events, we have more than 200 people tonight, and we always have a quite diverse audience for these events. So the first thing I was hoping to do here is to get us all on the same page with regard to what is happening and what the current status quo is. So for both of you, maybe Stephen first and then Melissa, could you please, for a non-legal professional audience, summarize what the most important developments were in the last 2 or 3 years with regard to both investment screening and export controls?
Sure, and thanks, Thilo, and thanks to everybody for your interest. So I think 2 years ago, there was new legislation enacted reforming CFIUS called FIRMA, the Foreign Investment Risk Review Modernization Act. And there have been two primary things that have flowed from that. One is new rules, and those new rules in particular expanded CFIUS's jurisdiction, that is, expanded the scope of transactions that the committee can review and ultimately impose conditions on the transactions that they review, or even forced divestment, block transactions or forced divestment. So an expansion of the rules, CFIUS's jurisdiction, and they created some transactions for which filings are mandatory. CFIUS has very broad jurisdiction to look at transactions, narrower categories created by this new legislation for which filings are mandatory. So those are the rules. That's the rules bucket. The second bucket is policy. This administration in particular has given CFIUS more resources, and CFIUS has utilized those resources in particular to hunt for transactions that have not been filed with CFIUS, transactions over which CFIUS had jurisdiction, but that were not filed with CFIUS, and more particularly Chinese transactions with some China vector have been of particular interest to the committee. So I think from my perspective, from the CFIUS perspective, the most significant developments are, one, the creation of new rules, expanding CFIUS's jurisdiction, creating some mandatory filing obligations for certain types of transactions, especially technology transactions. And then number two, the resources that have been used to hunt for transactions that were not filed, in particular China-related transactions.
Great. And then on the export control side, so when we do, just to level set, when we're talking about U.S. export controls, there's really sort of three sets of laws. There's the Commerce Department's Bureau of Industry and Securities Export Administration regulations, which will be the ones we will focus on mainly tonight. There's the State Department's International Traffic in Arms regulations. And then the sanctions regulations are the Department of Treasury's Office of Foreign Assets Control, various trade and economic sanctions regulations. And so I think the biggest changes, 2 or 3 changes in the past year or so. One is the connection of export controls with CFIUS. Stephen mentioned there are now certain mandatory filings for CFIUS, and the critical technology is a key to making many files mandatory. And that critical technology analysis directly ties to how is a company's technologies, product, software controlled for export control purposes. And so we do that analysis both under the Commerce Department's regulations and the State Department regulations. There's also other lists, but those are the 2 main ones to help determine whether or not you have a critical technology. So being able to identify classification issues, classify the technologies, and also know what the licensing requirements are now keys for both export controls and CFIUS. I think a second change, particularly with respect to doing business in China, is the expanded extraterritorial reach that the Commerce Department has taken with its regulations, particularly obviously regarding Huawei, and it's over 100 of its affiliates that have been listed on the entity list. As a result of some amendments in August of this year, now even transactions that really have no nexus to the US, they were either, you could have a foreign part that's designed using US origin software or that was produced overseas on a piece of US origin equipment, could now subject foreign entities to US export licensing requirements if Huawei is going to be involved in that transaction. So that is a huge reach. And then I think the third one is the expansion of controls on transactions that may involve a military end user for both China, Venezuela, and Russia, and how they've expanded sort of who are covered under those rules.
Fabulous. Thank you very much. If I could take it from the high level a little bit more down to the individual firm level, based on your experience dealing with investors on a day-to-day basis, how have these changes impacted, I guess, foreign investors in general, and then Chinese investors in particular, if you look at the entire spectrum of potential outcomes? So are we talking about marginally higher costs of risk assessment and compliance, all the way up to exclusion from certain markets? Where would you say are we coming out on average, and what are the main differentiators there?
Yeah, so I think certainly the new rules and including the mandatory filing rules have injected significant friction into international investment writ large, because for virtually any investment involving a non-US party making an investment into a US company, you have to at least stop and think about whether a filing to CFIUS is mandatory. So that in and of itself introduces friction. I think that in general, it's at this point increased cost, increased sort of compliance costs, but with respect to Chinese investors and potentially Russian investors, but certainly for Chinese investors, we have seen much more significant implication than just increased cost, because that certainly foreign direct investment acquisitions have fallen off a cliff, as I think Rhodium Group's writings attest. And even in the minority investments, we're, I think, seeing an effect with respect to Chinese investments, much more caution, and it probably is deterring significant amount of investment from Chinese investors. So that, and I think that's a result of the 2 things flagged. One, the new rules, together with the policy, which has been a fairly draconian policy by this administration, very, very skeptical of Chinese investment across the board. And so those 2 things together, I think, friction for most investors, more than that for Chinese investors.
Yeah, and Ted, I think, right, is even on the CFIUS side too, right? So we're doing a lot of counseling, and people, right, might want to be structuring investments now, so they're not subject to CFIUS jurisdiction. So that is, I figure, a growing part of our analysis as well. And then I think on the export control side, the biggest impact that we're seeing now is, right, the number of companies that need to come in and apply for licenses, particularly dealing if your product part component's going to be for end use, even in a Huawei product. And so we are doing lots of applications for U.S. companies, for foreign companies. Happy to report licenses are being issued. So it's not the rules requirement, but they're there. And companies really having to come in and try to verify, right, are they subject to the rule? How are they subject? And then doing sort of the classification analysis for them as well.
I think
go ahead, Steve.
I think to Melissa's point, it is important to emphasize that there are deals, including China-related deals, that are getting done. But the friction that the new regime has introduced is pretty substantial there. Sometimes certainly enough to reduce the flow, and depending on the sector, in some instances, really to bring it to a halt. But there are, in a variety of sectors, still deals being done, China-related deals being done, and that's important to emphasize.
Right. One follow-up question on that, and maybe flipping it around a bit to U.S. companies and sellers of assets. How has this environment impacted U.S. parties to transactions? Are Chinese buyers or partners by now a no-go, or would you say there is still appetite to engage in, say, bring Chinese VC partners on board or engage in licensing transactions with Chinese technology companies?
Yeah, well, as Melissa alluded to, we often spend time with both U.S. companies and investors structuring investments to ensure that to minimize CFIUS risk, and that can be done in a variety of ways, below certain thresholds, not obtaining certain rights. So we're spending quite a bit of time, and that is certainly a direct consequence of the new regime, that the parties do have to spend time if they really want to go ahead, and sometimes it does make sense to go ahead, structuring transactions to reduce risk and to specifically allocate that risk.
And I do think, depending on the sectors, so I think yes, U.S. companies do have an appetite and would like to continue to partner with the Chinese companies. And then, if the regulatory burdens aren't too high, I think they do want to pursue it. So if there's no mandatory CFIUS filing, obviously, then that gives them a little bit more flexibility. But as Stephen mentioned, they do have the risk of the enforcement now. But if you're in a semiconductor industry, as opposed, that might be more risky than if you're doing a cancer therapeutics or some sort of biotech or, therapeutics, health sciences. So I think we look at all those factors and the analysis and who is the Chinese investor to determine, what we think the risk assessment is and whether that would make sense for the U.S. company to proceed with the transaction.
And I think for acquisitions, the effect of this, the friction is probably more substantial than for investments. I think, especially for large acquisitions, the U.S. companies are going to be wary about whether they can get the deal done. So there's a pretty steep discount applied to any offer for full acquisition. I think that's less of an issue for minority venture investments, which we continue to see a pretty healthy flow. Though there too, it's sensible to spend a fair amount of time. And again, both the U.S. company and the foreign investors are spending a fair amount of time thinking about the risk and how to allocate that risk.
Great. And I guess from my perspective, one of the things that we have definitely seen over the past 3 years is a deflation of Chinese interest to build R&D facilities here in the United States. They have very much pulled back on those efforts. And I think that's certainly related to more scrutiny on the export control side.
And I do, Thilo, I think on that, it's an interesting point because we have seen that we've represented U.S. subs of Chinese companies. And if they develop the technology here in the U.S., they may need to get U.S. government authorized to send it back to China. And the government may not, and I have seen, not approve that license. Yep. So, I think it's a very tricky thing when you're doing that, even if you have foreign nationals in the U.S. doing it.
Yep. Great. So I'd like to transition over to talk a bit more about technology in particular, because the majority of our audience here is presumably in Northern California, Silicon Valley. So maybe, Melissa, a follow-on question for you in particular. Traditionally, the U.S. government has been mostly concerned about a fairly small and narrow set of dual-use technologies, weapons, and the like. Now it seems like the government is vastly expanding that definition, is now concerned about a much broader set of technologies, including ones that are being designated as emerging and foundational technologies. How expansive is that shift, and what is behind it?
Yeah, so I think the good news is, when the FIRMA was passed and it talked about this designation of emerging and foundational technologies, which were terms, but there was nothing designated under them. There was great concern that the U.S. government was going to unilaterally just start controlling broad groups of technologies, and that has not happened. So I think that's been a plus. And so I think most people in the government, particularly the Commerce Department, is trying to be very careful. And do want to designate new technologies. I think do pose a threat to national security or foreign policy if they're in the hands of the others. But they are trying to go through their multilateral regime, so it's not unilateral controls by the U.S. government. And they are doing it, fairly targeted. So there was certain geospatial AI software, or there's certain gene editing, software. So I think how it's being implemented has been much better. I do think the government has been interested in it for a while, but literally to implement the new regulations takes much longer than it does to develop the technology. And so the government sort of has always struggled, saying by the time we get the regulation in, the technology has already changed. And I think there was even a Federal Register notice, one of the official sort of publications, that whether like facial recognition software, sort of surprised that hasn't been more tightly controlled yet. But they literally can't draft the regulation to keep up with the technology. And so I think they're trying to do a little bit better about expediting that process. So
it's very much a moving target, and the lines are still in the process of being redrawn around these technologies. If you could pinpoint 2 or 3 areas where the marginal change is the greatest, what would they be?
Yeah. I feel like there hasn't, I think because they have been implementing them more tailored, and they are being very specific. You have to meet, and said when they had designated an emerging or foundational technology, and no foundational technologies have been designated yet, only according to Commerce, they have designated over 30, I think, emerging technologies. But what they're doing is they are putting them on the Commerce control list. So they are being treated the same as any other controlled technologies. And so you have to meet very specific technical parameters. And so even for the client base that we deal with, I feel like the new emerging technologies have not been a game changer for anyone. I think it was more, and still is, sort of the uncertainty about what is coming. Are they going to put it out for notice and public comment? That still is sort of the part that makes people uneasy. But I think the way they have been implementing them, at least for most of our clients, has not been a game changer.
Stephen, kicking that over to you. Do you see any tendencies or trends within specific technology areas, or is the same true for CFIUS?
Well, so one thing to emphasize, and to pick up on Melissa's comment, whether something is a critical technology, and emerging technology is a subcategory within the CFIUS universe. Emerging technology is one subcategory of critical technology. And whether something is a critical technology makes a big difference for whether there is a mandatory filing. But it doesn't necessarily make a big difference for whether CFIUS has a concern. That is, CFIUS is concerned about lots of things that may not formally fall under the category of emerging or critical technology. So we often are asked, well, if it's not a critical technology, then we don't have a concern, right? And that's not necessarily the case. There are, for example, lots and lots of AI developments, autonomous vehicle developments, blockchain developments, biotech developments that are not hitting the formal definition of critical technology, but that are of concern to CFIUS. And I mentioned at the top that CFIUS has had this fairly active outreach to non-filed transactions. And those are transactions, for the most part, that were not mandatory filing transactions, but were within CFIUS's broader jurisdiction. And they have indicated concerns about a broad array of technologies that have not been formally designated as critical technologies, but are clearly of concern to CFIUS. And those are things that the audience probably would not be surprised. These are often artificial intelligence, autonomous vehicles, blockchain, robotics, biotech. They often worry about almost anything that warrants the label new technology.
And surprisingly, a lot of those, as Stephen said, are not currently critical technologies. They may not be very tightly at all controlled for export control purposes.
Great. I want to, in a spirit of Silicon Valley, Stephen, a specific question for you on venture capital. One of the biggest marginal changes, I guess, is the expansion of CFIUS jurisdiction to some of these smaller stake transactions in the venture capital private equity space. And I wanted to ask you how the enforcement of these new provisions has been progressing over the last 2 years since CFIUS came about, FIRMA came about, and what kind of patterns you are seeing in enforcement in terms of getting to certain outcomes and to certain messaging in the marketplace.
Yeah. So first thing I would say is that it's new. This enforcement unit was created in 2019. It's really been up and running for just about a year. That's not, that doesn't provide a lot of data. Certainly, CFIUS asserts, the CFIUS staff assert that they're potentially concerned about investors from any country and a broad range of technology. In fact, it's been mostly China, almost exclusively Chinese investments that they have taken notice of, asked questions about. It takes them a very, very long time to move on these enforcement cases. So even the matters that they started bringing into the fold in the spring, it's still, or for many of these, there is no disposition. They ask a lot of questions. But I think the expectation, and consistent with our experience so far, is that large acquisitions and investments, including venture investments by Chinese investors into technology of the sort that we just mentioned, artificial intelligence, biotech, things that sound new to them, are likely going to be difficult, cause at least a long CFIUS process. And in the end, we have worked on some matters where CFIUS seems to have decided that it's not worth their time to force divestment. But unfortunately, CFIUS doesn't typically give a "you're done." They sort of leave it hanging. And so it's often, almost always, impossible to know that they're done for sure. And that's a big problem with the regime, is that once they start asking, there's a cloud that hangs over the transaction, and it may be a year or more before you feel comfortable that cloud has dissipated.
And I think, right, there is no statute of limitations when CFIUS can reach out. So if you close on a transaction, 3 years has passed, it still doesn't mean CFIUS can't come knocking at your door.
How has FIRMA and enforcement action changed the behavior within the VC community? Has it made a very big impact, or would you say that the reaction is fairly segmented so far?
I think it's hard to speak in general terms, because there are so many stripes. There are very large sort of institutional firms that are in general more cautious, and then others who aren't. There are some that have become quite cautious, less so on the company side, but on the investor side. Even if they're U.S. investors, they may be concerned about co-investors and may ask a lot of questions. On the other hand, there are certainly lots of folks, both on the company side and the investor side, who will say, look, if it's not mandatory, or as long as there's an argument that it's not a mandatory filing, let's just get on with it. So I think the short answer is the reaction is varied.
Great. I'm gonna wrap up this section here by pulling in two questions from the audience actually already, and I think it probably for Melissa. The questions are: number one, is there any indication as to when the list of foundational technologies will be published? And kind of related to that, have you seen any changes or new concerns that have arisen within the broader context of export controls and CFIUS in the COVID-19 context with pharma and biotech in particular?
So as to foundational technologies, I think we are still a ways away. The only thing that has been issued so far, I think, is an advance notice of public rulemaking. It was very basic, and I think the Commerce Department was pushed to sort of get something out. So there have been no foundational technologies even proposed. And I believe the way the Commerce Department will do it, which is the way they've been doing mostly the emerging technologies, is they will propose certain foundational technologies, put those out potentially for public comment for maybe 90 days, and then sort of issue new regulations. So I think we are still a ways away before finding having any new sort of, or any foundational technologies newly added to any of the control lists. As far as biotech and pharma, I think with COVID, I haven't seen too much. The licensing clearly the export agencies have been very busy during COVID, issuing amendments and tightening their controls and expanding their jurisdiction. But most of that really has focused on the Huawei entities or military end users, and so haven't seen sort of any issues yet. A lot of medical items that don't require export licenses or pharmaceuticals. There has not been any sort of increased licensing I've seen of that. So I would say COVID has not had a material impact on the export controls in that area.
Great. Stephen, did you want to add anything to that COVID question?
No, I think I'll stand pat with Melissa's answer.
Great. Well then, I want to pull us out a little bit. We've seen a lot of news coming out over the last couple of weeks and months about investment screening framework in the European Union being implemented. The UK just came out with some fairly interesting new proposed rules on their own investment screening. And we had the same coming out in Europe on export controls. We had China actually updating its export control regime. So one question also for both of you is, could you give us a sense as to how the United States compares internationally in terms of its the level of scrutiny restrictiveness for cross-border transactions, both in terms of perception and actual reality? Where are we? Are we an outlier, or are we just a first mover?
I think it's a little early to I think ask in 2 years, and we may be better able to answer. At least a first mover, CFIUS has been the rules and especially the enforcement activity have introduced the friction that we've spoken about, but and there are other regimes that have rules that are similar, but the enforcement hasn't been there, and so it hasn't. My sense is that has not caused the type of friction that the U.S. system has caused. Having said that, in part because CFIUS has pressured foreign governments to enact and enforce similar regimes, We are seeing changes. The UK change that you alluded to, just introduced last week. We are seeing changes in the rules, and if the foreign governments start to put resources to the enforcement activity the way CFIUS does, then I would say we aren't an outlier. We're just a first mover. But at this point, we're an outlier, at least with respect to enforcement. The UK regime that was introduced last week is a pretty, at least as introduced, it may not end up this way, but seems to be a pretty onerous regime. And if there is real enforcement there, they will have one-upped CFIUS.
And I think on the export side, I do believe the U.S. probably has the most robust and sort of complicated and well-established export control system, right? I mean, every time you do a transaction, you need to look, is there a license requirement based upon the technical specifications of the item? Who's, then analysis, who's the end use and end user? And the, obviously the extraterritorial jurisdiction, the Commerce Department's position is any U.S. origin item that has their jurisdiction, whether it's a technology, commodity, or software, they continue to keep jurisdiction over that even when it's overseas, as long as it's not incorporated into, foreign produced item. But, and their ability, as we've seen, to use sort of these lists, the entity list, the list of denied persons, to sanction foreign companies is, I think, quite aggressive. And it's not hard to get on the entity list. It's hard to get off. It's much harder to get off than put on. And so, I think we've heard a lot of rumors of China was sort of going to come up with a similar list to the entity list, I think, to try to sort of combat what the U.S. is doing. I don't believe they've done that yet, but I do think the U.S. is sort of definitely takes their export controls more seriously, more aggressively than the other countries.
Great. We're just watching the clock here. I think wanted to move us slowly towards the current situation and the outlook, because that's what everybody is most interested in, probably. So we are in the midst of a transition process, apparently, to a new U.S. administration, and so maybe starting with the high-level question to both of you. Looking back, how much of this change over the past 5-6 years was driven by the Trump administration, and what leeway does a new Biden administration have to dial up or down the level of scrutiny and or political frictions?
So I think it is important to understand that a lot of the changes that happened in the Trump administration are now law. And so some of the friction is almost certain to persist because it is a function of the law and the regulations that CFIUS has rolled out, and those are not likely to change. So the mandatory filing, for example, and the need to check to ensure that it's not a mandatory filing, that's going to persist indefinitely. The administration, though, does have discretion to treat transactions more or less harshly, and to pursue more or fewer unfiled, non-filed transactions, at least in the CFIUS realm. I think the conventional wisdom to which I subscribe is that the Biden administration is unlikely in the CFIUS realm to make major changes vis-a-vis Chinese investment. However, they may be less reflexive. We have seen in the Trump administration a sort of reflexive anti-China tilt, a skepticism that any Chinese acquisition or investment could be a good thing. And that might change in a Biden administration. The President-elect Biden has indicated himself, and many of his advisors have said that there are and should be areas of collaboration, climate change, healthcare, green energy, things like that. And so we may, in certain areas, get a little bit of a pullback.
And I think in the export controls, it will be similar. I mean, both FIRMA and the Export Control Reform Act, they were passed with very strong bipartisan support. One of the few areas where there has been support. So I think the focus, particularly on export controls, on tightening, the focus on China will stay. But as to policy, I think, potentially we could see some relaxation. I don't think any material changes will be immediate. But, potentially which licenses, maybe more licenses will be approved. I think there'll be less use of sanctioning people, putting them on the entity list, which requires any item subject to U.S. control, basically, to need a license before it can go to these entities. And so I think we will see some more restraint in using those. And potentially, we'll see if they walk back at all on the August 2020 amendments, which I personally think were quite a stretch. So we'll see.
Any chatter, any rumors as to political appointments that could make a difference out there in both areas? Was reading about Mr. Wolf for the past couple of weeks that leaked out. Do you have any additional color to what extent that will matter at all?
Yeah. I think, those decisions can make a big difference. I don't see on the CFIUS front, I don't see a lot of incentive for the Biden administration to put a lot of muscle into reducing the friction. I think that, as Melissa said, this, a lot of this has been in this area, export controls and foreign investment screening has been bipartisan in nature. But it is possible that somebody, for example, a deputy Treasury Secretary, and historically the deputy Treasury Secretary has gotten involved in CFIUS, and if there were somebody in that position that really wanted to try to either reduce the friction or increase the friction, that would have a significant effect. So those choices do make a difference. My guess is if it were one way or the other, it would probably reduce the friction, that we might see a less reflexive anti-China approach, but we don't know. And best guess is that there won't be a whole lot of movement there.
Yeah, and I think similar on the export side. If they bring in someone said like a Kevin Wolf, who already was there under the Obama administration, is very knowledgeable about export controls, then I think we would see again a more calm and thoughtful and hopefully transparent process, sort of with the rule changes and what the government means by them. And so I think, it will depend. But if they do bring in people that are familiar with this area, I think we will sort of go back to better days with the agencies and having clarity about exactly what these new requirements mean and how they intend to implement them.
Great. There are two really good questions from the audience that I like to pick up here. One of the hopefully landmark steps by a Biden administration in the broader China policy realm would be to coordinate with allied nations on defensive and other policies. Do you see any prospect for more of a multilateral or coordinated approach in those two areas, investment screening and export controls? And in particular, we've seen a whitelist approach within CFIUS. Is that a path forward that would make things easier and especially more effective?
Yeah, I mean, I certainly think that the administration will try to do that. One of the things that makes that difficult in the CFIUS realm is that the nature of the CFIUS process is so case specific. Policy effectively gets made by case by case. And so that makes multilateral coordination a bit of a challenge. But, there is a whitelist of there's such a thing as accepted investors. And it's possible right now, the list of accepted investors is, it is a complicated to become an accepted investor. The investor has to jump through many, many hoops. The only investors that are eligible for meeting accepted investor status are those from the UK, Canada, and Australia. we could see a broadening of that list. New Zealand was notably not included. Perhaps they will be in the future. So that is possible. And I hope that we see some of that. But it is CFIUS, even if you are from one of those countries, it still is difficult to meet the accepted investor test. And as I said, it's hard by its nature. CFIUS is sort of case by case, and that makes coordination challenging.
Yeah, and on the export control side, I think there is, that is much more amenable to sort of a multilateral approach. So there are various multilateral regimes. The Wassenaar arrangement is the number one. That is where most of the dual use regulations are. I forget how many countries are in there. I think well over 40 now. And they meet every year, and countries come in with their proposals about what to control. And those countries all try to harmonize their control list. So you're not putting, your country at a disadvantage because you're imposing unilateral controls on that technology. And then, other people go to other countries to buy it with less restriction. And so, particularly the Commerce Department, Bureau of Industry Security, they are very active participants in that multilateral regime. And I know this is where we have been pleased, particularly with the emerging technologies. They have been trying to use those processes to designate the technologies and not just issue unilateral controls. So I think that is something we will continue to see, even if not more, if the administration changes.
Great. So as I said in the beginning of this section here, we're not quite there yet. We still have a few weeks to go. So one question for you, what damage could be done in the next 2 months with regard to investment scrutiny and export controls in particular, but also a broader set of related policies? We've seen President Trump coming out with a number of executive orders, one on WeChat and TikTok. Last week, we had another one on restricting U.S. investment in about 31, I believe, Chinese companies. Do you have a perspective on within the next couple of weeks, within that time frame, what else could happen, and what impact could that have in the medium long term?
Yeah, so I think one of the challenges in this administration, that most regulatory lawyers have faced, is that there have been lots of pronouncements about broad initiatives, especially vis-a-vis China, that lack implementing detail. And so we saw that, for example, just a short time ago with the ban of sorts on transactions involving securities in 31 different Chinese companies. And that lacked a lot of detail that regulatory lawyers need to guide clients with any confidence. So it would not be surprising if we saw more of that in the last in the waning weeks here, and it is not so easy for an incoming administration to clean that stuff up. It takes on a momentum of its own, and there may be a lack of political incentive to clean that up. So I do see the potential, and maybe even likelihood of more of that activity. Fortunately, in CFIUS, in some ways, it has a large staff and a set of practices that are followed. I think the TikTok case is an example of deviations from some of that standard practice. For example, confidentiality, the amount of publicity surrounding the TikTok case is highly unusual, and I think most CFIUS personnel would say regrettable. And so it's also possible that we could see damage to sort of norms and institutions, though I hope that doesn't happen with respect to CFIUS, but it could.
Yeah, and I think you said with export controls, we talked about the regulation process is usually, takes some time because it is an interagency process, and often, regulations are put out for notice and public comment. They don't have to be. and he can issue a lot of executive orders, but right, if they don't have the implementing regulations, they may not mean much. But the use of, said, the entity list, where it's not that hard to put people on, the level's fairly low, and there's serious consequences for being on that. So if the administration wanted to add more entities, persons to, say, the entity list or another sanctions list, that's where I could think that could have some lasting implications well past the administration, because again, the removal process is complicated and time consuming.
Maybe to follow up briefly on Stephen, what you said. You served on CFIUS, and for a long time, CFIUS was this black box for investors, and there was always a bit of a shred of uncertainty around it. The certain conduct by the Trump administration has certainly further aggravated that perception and damaged the reputation of CFIUS. How hard do you think will it be to just psychologically reestablish the narrative that CFIUS is nonpartisan, non-political?
I think it'll be difficult, and I think the CFIUS staff and the political officials are going to have to work hard. I think they are going to want to return to try to regain that perception that it's not political. But that's that damage will be hard to repair. So I think it's just time. It's persuading the public that they're making rational decisions. I think that CFIUS is hurt in terms of its ability to reestablish that perception by the fact that they provide. It is, I think, the perception of it even beforehand as a bit of a black box is fair, and I think that CFIUS probably in some ways it hurts itself by taking the confidentiality norm too far. I think there are ways in which the committee could give out more information than they do to try to persuade people that they are making reasoned, non-political decisions. And I think that's something that they should consider in this new administration, though I don't expect it to happen. But I hope it will, and I think they could be strengthened. The norm of non-political decisions in the CFIUS process could be strengthened by putting out more information about the nature of their decisions.
Yeah, and I think right in the export world, it's a little bit more objective. There's clearly is some subjectivity about what licenses you do approve or deny or put conditions on, but there are very clear steps about when you need to apply for a license. And there are interagency process to escalate it if there's not a consensus on how it should be. So I think hopefully, continued transparency and communication by the export control agencies will be helpful, but I think they don't have as much of an uphill battle as CFIUS.
Yeah, and part of the battle with CFIUS is that it is a committee, and so one of the norms of rule of law is that you know who makes the decision, and they offer public-facing reasons for the decision, and that doesn't exist with CFIUS. It's this sort of mishmash of decision makers. You don't really know who it is, and they don't really offer public-facing, even to the parties, much in the way of reasoned decision making. They've moved a little bit in that direction in the last several years, but not much. And I think that's a problem. But as I said, somebody at the Deputy Treasury Secretary could take it upon herself or himself to make a change there, but they'd have to really feel there's not a lot of political incentive to do that. And so they'd really have to feel a burning personal desire to create that type of reform.
Great. I think we're close to the end. We have a couple more minutes, I believe. So let me maybe throw two more questions from the audience at you. Melissa, for R&D projects, Slav wants to know how expansive is the fundamental research exclusion? And then one last one for Stephen. When it comes to M&A and CFIUS, could you briefly catch us up on the evolving role of data and access to personal information?
Yeah. So the fundamental research exemption, right? So what that means is if companies, universities are engaged in fundamental research, that will not necessarily be controlled under the regulations. So we see that a lot in the university context, right? And sort of one of the key triggers is it's the type of research and development that, is supposed to be published, is supposed to be a matter of public record. If a university is doing paid research by a company, that is generally not going to qualify as fundamental research. So there are very specific boxes that need to be checked in order to fall within that exemption.
Yeah, on access to data. So, this has been a long-running CFIUS bugaboo for at least the last 6 or 7 years, that companies that have a lot of access to sensitive personal data about U.S. citizens, CFIUS is concerned about that data getting into the hands of foreign investors, and particularly Chinese and Russian investors. That had been a long running concern. In the last couple of years, as CFIUS has issued these regulations, one of the rules defines sensitive personal data, and it defines it in a pretty complicated way. If the sensitive personal data held by the US company meets the definition in the CFIUS regulations, this fairly complicated definition, that can give rise to a mandatory filing. Even if it doesn't give rise to a mandatory filing, and even if the type of data or quantum of data is such that it is not formally categorized as sensitive personal data, nevertheless, a significant amount of sensitive personal data, even if outside the formal definition, will often cause CFIUS concern. So we often have clients say, okay, you've said it's not a sensitive personal data business, it means we don't have to worry. And unfortunately, that's not the case. CFIUS always looks, when they do the analysis as to whether they have a concern, they look at the nature of the US company, including whether they're holding sensitive personal data, what type of technology they have, and the threat presented by the foreign investor. And those two things are what comprise the CFIUS risk analysis. And so a modest amount of sensitive personal data, if the investor is of concern to CFIUS, may still give rise to CFIUS concern. So that is the state of play, I suppose, is that there is a set definition that is very likely to trigger CFIUS concern, and then an amorphous area where if you have data paired with an investor that may be of concern, that will also give rise to CFIUS concern, even if it doesn't fall into the formal definition.
Great. We are coming to an end, but I would like to ask one last question really, really briefly to both of you, Stephen and Melissa. Tying it back to the level of Chinese investment that we're seeing, which has dropped dramatically. We are in 2020 at an 11-year low when you look at both M&A and venture capital and greenfield combined. So we really have reached a bottom. Looking forward to 2021, there are some indications that a Biden administration might be able to dial down frictions. Stephen, Melissa, what are some of the signals that you're getting from the Chinese investors that you're working with in terms of what types of investments and activities in the United States they are still interested in, or that might come back once some of that political uncertainty is resolved?
Yeah, I think, well, there have been seem to be a lot of investors waiting in the wings generally to see what the Biden administration position is. And I think, some of the areas to which we alluded earlier where Biden has sort of signaled that there are areas for collaboration, clean energy, healthcare, other in companies that are focused on on climate change. Those are areas where I think we'll see a little bit more activity. I expect that we'll still see wariness in some of the hot button issues like semiconductors, artificial intelligence. We, I think have seen less of a drop off with respect to venture investment than M&A. And so it wouldn't surprise me if we start to see a little bit more China-related activity in venture and then potentially in M&A, depending on how things go. I don't know that it'll be sort of a flood in a particular industry or set of industries. I suspect it'll be a little bit across the board with avoidance of some of the most hot button things like semiconductors.
Yeah, and I obviously consistent with what I'm seeing. If we do see a change, and even though CFIUS cases are confidential, if there is some progress and people are hearing that there are going to be some clearances issued, then I would think, right, we will start seeing perhaps an uptick of more. But until I think we start seeing those, I do think they're going to be cautious, particularly about the semiconductor and those sort of tech industries, and maybe be a little bit more amenable to the life sciences and biotech.
Fantastic. And with that note of cautious optimism, I want to thank Melissa and Stephen for spending their evening with us, and pass it back to Margaret to close us out.
Thank you.
Thank you. Thank you, Stephen, Melissa, and Thilo. We've been following CFIUS closely, and we know we need to continue to do that. Thank you for helping us do that, and hope you can come visit us in person. Aegis Society has been hosting global virtual programs around the world. You can check out our program listing at aegissociety.org/online. We're a nonprofit. If you'd like to make a donation to us, please reach out to us as well. One program you're not going to want to miss, January 14th, it's our 3rd annual Future of U.S.-China Conference. We're honoring George Shultz, our honorary chair. He's turning 100 years old next month, and Dr. Henry Kissinger is also going to join us for that program. You can also follow everything that we do on social media, on Instagram and Twitter, using the handle at Aegis Society SF. We put up a lot of content from our speakers and from our board, so please follow us and connect. For those of you that are joining our VIP reception, please click over to the second link that was emailed to you right before this program. Thank you again to Wilson Sonsini Goodrich and Rosati for sponsoring us. We really appreciate that, and you, Barry Taylor, as well. Thank you to our team, and from all of us at the Northern California Center, stay safe.